Welcome to meeting number 91 of the House of Commons Standing Committee on Public Safety and National Security. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using the Zoom application. I would like to make a few comments for the benefits of the witnesses and members. Please wait until I recognize you by name before speaking. To prevent disruptive audio feedback incidents during our meeting, we kindly ask that all participants keep their earpieces away from the microphone. Audio feedback incidents can seriously injure interpreters and disrupt our proceedings. A reminder that all comments should be addressed through the chair. Pursuant the order of reference of Monday, March 27, 2023, the committee resumes its study of Bill C-26, an act respecting cybersecurity, amending the Telecommunications Act, and making consequential amendments to other acts. We have today two panels of witnesses. I would like now to welcome our witnesses for the first panel. Business Council of Canada, Vice President, Policy and Legal Counsel, Trevor Nyman, welcome. Canadian Internet Registration Authority, Byron Holland, President and CEO, welcome. Up to 5 minutes will be given for opening remarks, after which we will proceed with rounds of questions. Welcome to all. Now I invite Mr. Nyman to make an opening statement, please.
Mr. Chair, committee members, thank you for the opportunity to take part in your study of Bill C-26. Founded in 1976, the Business Council of Canada is composed of approximately 170 chief executive officers who run Canada's most innovative and successful businesses. As an organization representing a broad cross-section of Canada's critical infrastructure sectors, I'll restrict my comments today to Part 2 of the bill, the proposed Critical Cyber System Protection Act. I'll begin my substantive remarks by underlining that Canada's leading businesses are committed to maintaining a strong and resilient security posture in the face of growing cyber attacks. Indeed, in a survey of our members, every single chief executive officer indicated that cybersecurity was either a high or very high priority for their business. Our members are backing their commitment to cybersecurity with significant resources. In critical infrastructure sectors, most of our member companies each invest well over $100 million in Canada per year on measures to prevent, detect, and respond to cybersecurity incidents. A plurality of these same members invest over $500 million individually on the same. As cybersecurity risks to the country grow, so too do the resources that our members plan to devote to protecting Canadians. Over the next 2 years, over two-thirds of our members plan to increase both their cybersecurity spending as well as personnel staffing by at least 25%. However, we cannot lose sight that defending Canadians against cyber attacks is very much a team sport, requiring close coordination between government and industry. That is why the Business Council of Canada supports the objectives of recent government cybersecurity initiatives. This includes Part 2, which, if properly drafted and implemented, can improve the overall cyber resiliency of the Canadian economy by establishing a baseline of cybersecurity across critical sectors. It's also important to note that the enactment of Part 2 would bring Canada's cybersecurity framework in line with best practices amongst our closest security partners. In a period of growing global tensions, Canada must move in lockstep with its closest allies and strengthen its cyber resiliency. Otherwise, Canada risks being perceived as a weak link, which could have severe consequences for Canadians' future security and prosperity. Of course, no public or private sector initiative is perfect. It should therefore be no surprise that Canada's business leaders would like to see targeted amendments to Part 2. In the interest of time, I will highlight just 3 of the most common suggestions for improvements that I've heard from our members. First, Part 2 should be amended to adopt a risk-based methodology, which would impose regulatory requirements on designated operators proportionate to their level of risk. By imposing fewer and less onerous obligations on low-risk operators that have well-established cybersecurity programs, they could spend more of their finite resources on incident prevention activities. Regulators, on the other hand, could dedicate more of their finite resources towards high-risk operators that pose the largest threat to Canadians. Second, Part 2 should be amended to place fair and reasonable limitations on Cabinet's power to issue cybersecurity directions. In the absence of statutory safeguards, Part 2 would allow Cabinet to issue any direction, regardless of whether such a measure would be effective in reducing a risk to a critical cyber system. Directions could also be issued without Cabinet first consulting with impacted provinces and territories, negotiating in good faith with designated operators, or considering relevant factors such as the potential cost of a direction, whether reasonable alternatives exist to issuing a direction, or the potential consequences of the direction on competition, services, or customers. Third and lastly, Part 2 should be amended to define key terms more precisely, such as cybersecurity incident and critical cyber system. The The current definitions of these terms are overly broad. This would likely result in reporting inconsistencies as well as the over-reporting of immaterial incidents, which could overwhelm government authorities. I'll conclude by noting that Part 2 is just one of several national security reforms that are urgently needed to protect Canadians. As a priority, the Business Council of Canada urges that lawmakers also amend the CSIS Act to enable CSIS to proactively share threat intelligence with Canadian companies where it's in the public interest and subject to all necessary safeguards and oversight. This and nearly 40 other much-needed reforms are included in the Business Council of Canada's most recent report, Economic Security is National Security. That report is publicly available on our website. Thank you for the opportunity to speak. I look forward to your questions.
Thank you. Mr. Holland, please.
Mr. Chair, members of the committee, my name is Byron Holland, and I am the President and Chief Executive Officer of the Canadian Internet Registration Authority, or CIRA. Thank you for the invitation to share our views and recommendations on Bill C-26. CIRA is a private not-for-profit organization best known for operating the .ca registry with 3.4 million .ca domain names under management. CIRA's core mandate is a safe, stable, and secure operation of the .ca domain and the global network that ensures it's available no matter where in the world you are. We also have a broader mission to promote a trusted internet, which we work towards by providing high-quality registry, domain name system, and cybersecurity services, and by investing in the internet community in Canada. CIRA participates in numerous fora to promote the security and resilience of the internet. Recently, this has included ISED's Canadian Forum for Digital Infrastructure Resilience and the CRTC Interconnection Steering Committee. We are also long-time participants in global internet governance. This includes extensive engagement with the Internet Corporation for Assigned Names and Numbers, or ICANN, the global overseer and coordinator of the domain name system that ensures that your web browser can reach websites like Canada.ca. We also contribute to the Internet Engineering Task Force, or the IETF, where the technical standards that underpin the Internet are developed. CIRA also provides cybersecurity services to help Canadians stay safe online, and they include Canadian Shield, our free cybersecurity service that protects an estimated 4 million Canadians from online threats, DNS Firewall, our enterprise-level DNS protection used by more than 1,000 Canadian organizations, including numerous critical cyber systems, and Anycast DNS, our global infrastructure that increases the performance and resilience of top-level domains like .ca and helps mitigate malicious activity such as distributed denial of service attacks from foreign actors. Moreover, CIRA collaborates with several institutions to keep these services up to date, including the Canadian Centre for Cybersecurity and the Canadian Centre for Child Protection. CIRA strongly supports the government's objective to raise the baseline level of cybersecurity across critical infrastructure through Bill C-26, and we offer 3 recommendations to Part 2 of Bill C-26, also known as the Critical Cyber Systems Protection Act, or CCSPA, to better balance the bill's cybersecurity objectives with well-established best practices in oversight, information sharing, and transparency. First, to promote more effective oversight, the issuance of cybersecurity directions under the CCSPA should be subject to Section 3 of the Statutory Instruments Act. This would ensure that cybersecurity directions are examined by the Clerk of the Privy Council in consultation with the Deputy Minister of Justice. Second, to increase confidence in the proposed information sharing enabled by the CCSPA, conditions on the use of information should be strengthened. Currently, Bill C-26 does not explicitly limit how government entities can use information collected under certain sections. For example, CIRA believes it would not be appropriate for CSE to use data collected under Section 15 of the CCSPA for purposes other than its cybersecurity and information assurance mandate. And third, to promote transparency, the CCSPA should be amended so that information on cybersecurity directions is reported to Parliament on an annual basis. This would include information on the number of cybersecurity directions issued and revoked, as well as the number of designated operators impacted. We have provided specific legislative wording for each of our recommendations in our written submission. In conclusion, SECU recognizes the need for some level of secrecy and timeliness in matters of national security and public safety. However, secrecy and expedience must be counterbalanced by the addition of provisions in Bill C-26 that would enhance Canadians' trust and confidence in the proposed legislation. Thank you.
Thank you, Mr. Holland. Now we're going to move right into questions. So I'll now open the floor to questions. And Mr. Motz, you're up first for 6 minutes.
Thank you very much, Chair, and thank you for the witnesses for being here. While I certainly and my colleagues agree that C-26 is an important piece of legislation that's a long time coming and we need to protect our critical infrastructure, I'm going to take this opportunity to move the following motion that's been properly placed before the committee. That in light of the recent federal court ruling, which found that the government's use of the Emergencies Act in February of 2022 to have been illegal, and that the special criminal laws subsequently created by the Liberal cabinet to have been an unconstitutional breach of Canadians' charter rights, the committee undertake a study pursuant to Standing Order 108-2 of the Department of Justice's role in supporting the government's illegal and unconstitutional decisions concerning the Emergencies Act, together with the consequences which follow the court's decision, provided that A, the committee invite the following to appear separately as witnesses for at least 1 hour each. 1, the Honourable David Lametti, the Minister of Justice and Attorney General of Canada at the time. The Honourable Marco Mendicino, the Minister of Public Safety at the time. Number 3, the Honourable Arif Virani, the Minister of Justice and Attorney General of Canada. Number 4, representatives of the Canadian Civil Liberties Association. And number 5, representatives of the Canadian Constitution Foundation. And B, an order to issue for all legal opinions which the government relied upon in determining that 1, the threshold of threats to security of Canada is defined by Section 2 of the Canadian Security Intelligence Service Act, required by Section 16 of the Emergencies Act had been met. 2, the thresholds required by paragraphs 3A or B of the Emergencies Act concerning a national emergency had been met. 3, the situation could not effectively be dealt with under any other law in Canada as required by Section 3 of the Emergencies Act. 4, the emergency measures regulations were compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act. And number 5, the Emergency Economic Measures Order was compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice, provided that these documents shall be deposited with the clerk of the committee without redaction and in both official languages within 7 days of the adoption of the order. Now, it's critically important that we understand why it is that we are bringing this motion forward. It is very, very important to remember that the federal court, rendered a decision last week that was critically important, and it should have been a landmark for this country and for this government. In order for us to have a clear understanding of what the Emergencies Act was about, how it came to be, the decision of this federal court, and all those sort of different nuances, I want to take some time just to do a very paraphrased version, a summary of the federal court, just a couple of pages. So in Ottawa on January 23rd, the Honourable Justice Richard Mosley of the federal court issued decisions. And in summary, 4 groups applied for judicial review of the decision by the Governor and Council to declare a public order emergency under the Emergencies Act. The February 14th, 2022 proclamation declaring a public order emergency, herein referred to as the proclamation, and the enactment of temporary special measures in order to deal with protests in various parts of the country which included the occupation of the downtown core of Ottawa and blockades of ports of entry, were under review. Now, this was the first time the Act was invoked since it was enacted in 1988. The proclamation, the Emergency Measures Regulations, the Emergency Economic Measures Order, adopted under the Act, had a threefold impact. A, they provided a range of activities relating to protests in designated areas. B, they required third parties to assist police in ending the protests. And C, they authorized financial institutions to disclose information on designated persons and entities to federal officials and to suspend their accounts. Justice Mosley goes on to write that the applicants and parties raised issues which led to the following questions. 1, was the proclamation unreasonable? With respect to the first question, the court considered the decision under the reasonableness standard of review and concluded the answer was yes, the proclamation was unreasonable and illegal. Those of you who are lawyers will understand ultra vires. The court said that they acted beyond one's legal power and authority. That's the Latin term for what ultra vires means. Means literally it's beyond the scope or excess of power and authority. While the court recognized that the occupation of downtown Ottawa and the blockades of the ports of entry were matters of serious concern, calling for government and police action, the threshold of national emergency required by the Act was not met. Under paragraph 3 of the Act, a national emergency is an urgent and critical situation that exceeds the capacity or authority of provinces to deal with it, and that cannot be effectively dealt with under any other law in Canada. The proclamation applied the temporary special measures in all of Canada's provinces and territories, despite the lack of evidence that it was necessary. Apart from the situation in Ottawa, the police were able to enforce the rule of law by applying the criminal code and other legislation. While the conclusion of the proclamation was illegal, ultra vires, it was sufficient to dispose of the applications. The court addressed the other issues should it be found to have erred in its findings on the first question. Second, the court considered the threshold of threats to the security of Canada. Section 2C of the Canadian Security Intelligence Services Act, or the CSIS Act, defines threats to the security of Canada as activities directed towards or in support of the threat or use of acts of serious violence against persons or property for the purpose of achieving a political, religious, or ideological objective. Section 17 of the Emergencies Act, or under Section 17 of the Emergencies Act, the Governor and Council required reasonable grounds to believe that the standards set out in Section 2 of the CSIS Act had been met. The evidence in the record before the court did not support a finding that the impunged activities required that or reached that threshold. The second question, as put forward by Justice Mosley, was, did the powers created by the regulations and the economic order violate sections 2B, 2C, 2D, 7 or 8 of the Canadian Charter of Rights and Freedoms? And if so, could they be saved under section 1 of the Charter? So what do those sections actually say in the actual Charter? Section 2 says, everyone has the right following fundamental freedoms: freedom of conscience and religion, freedom of thought, belief, opinion, expression, including freedom of the press and other media of communication. C, freedom of peaceful assembly. And D, freedom of association. 7 talks about life, liberty, and security of the person. Everyone has the right to life, liberty, and to the security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. And Section 8 of the Charter deals with search and seizure, and everyone has the right to be secure against unreasonable search and seizure. And Justice Mosley said if they could be saved under Section 1 of the Charter. Section 1 says that the Canadian Charter of Rights and Freedoms guarantees the rights of, and freedoms set out on it, subject only to the reasonable limits prescribed by the law, as can be demonstrably justified in a free and democratic society. Concerning the Charter, the Court found that the regulations infringed the guarantee of freedom of expression under Section 2B, as they were overbroad in their applications to persons who wished to protest but were not engaged in activities likely to lead to a breach of the peace. The economic order infringed on Section 8 of the Charter by permitting unreasonable search and seizure of the financial information as designated persons in the, and the freezing of their bank accounts and credit card accounts. The infringements of Section B and Section 8 of the Charter were found to be not minimally impairing and could not therefore be justified under Section 1 of the Charter. The Court found that there was no infringement of the rights to freedom of peaceful assembly and of association in paragraphs 2C and 2D of the Charter, and any infringement in Section 7 respecting the liberty interests of the individual was found to be in accordance with the principles of fundamental justice and thus not a breach of the Charter. Now, I think it's important to understand why and how things transpired. How come we had a protest, and how did we get to this place in the first place? It has to do with the increasing degrees of overreach and abuse of power by the Liberal government and their trampling of the charter rights of Canadians. In January of 2022, nearly 2 years after the start of the COVID pandemic, Canadians were growing frustrated with government restrictions and mandates. The straw that broke the camel's back was the order that truckers, cross-border truckers especially, and other essential workers would no longer be exempted from vaccine requirements. This was a threat to their livelihoods and a violation of their rights. And for them, enough was enough. They gathered from across Canada and came to Ottawa and other locations to voice their frustrations, but also to be heard by this government. And I think it's important to understand that this government had no interest in listening to them. And I know that firsthand. I personally, vigorously worked behind the scenes to arrange meetings between then Minister Alghabra, Minister of Transportation, then Minister of Public Safety, Marco Mendocino, to meet with protest organizer Tamara Litch, with the understanding that such a conversation would result in the protest being dismantled. However, all attempts to make that happen, personally with them, whether even on a phone call, they refused to do that. The government completely refused, and I think, quite honestly, that their unwillingness to dialogue from the very beginning, had they changed their attitude, they would have certainly, this situation would have been certainly a totally different, and it could have been avoided. The Prime Minister also added to this. He seemed to be fine stoking division, calling people names, allowing frustrations to grow and tensions to grow, until a point where he and his cabinet decided to take their overreach and disregard for charter rights to the next level by stepping outside of the law and their lawful authority and invoking the Emergencies Act for the first time in history. And exactly what did that order say? And I think it's important that Canadians are reminded of what the Emergencies Act actually said. And I will quote from the February 14th, 2022 Government of Canada Bulletin. Whereas the Governor and Council believes, on reasonable grounds, that a public order emergency exists and necessitates the taking of special temporary measures for dealing with the emergency. And whereas the Governor and Council has, before declaring a public order emergency, and in accordance with subsection 25(1) of the Emergencies Act, consulted the Lieutenant Governor and Council of each province, the Commissioners of Yukon and the Northwest Territories, acting with consent of their respective executive councils, and the Commissioner of Nunavut. Therefore, Her Majesty, the Governor General and Council, on the recommendation of the Minister of Public Safety and Emergency Preparedness, pursuant to Section 17(1) of the Emergencies Act, directs that a proclamation be issued. A, declaring that a public order emergency exists throughout Canada and necessitates the taking of special temporary measures for dealing with the emergency. B, specifying the emergency as constituting 1, the continuing blockades of both persons and motor vehicles that is occurring at various locations throughout Canada, and the continuing threats to oppose measures to remove the blockades, including by force, which blockades are being carried on in conjunction with activities that are directed toward or in support of the threat or use of acts of serious violence against persons or property, including critical infrastructure, for the purpose of achieving a political or ideological objective within Canada. 2, the adverse effects on the Canadian economy recovering from the impact of the pandemic known as the coronavirus disease, COVID-19, the threats to its economic security resulting from the impacts of blockades of critical infrastructure, including trade corridors and international border crossings. 3, the adverse effects resulting from the impacts of the blockades on Canada's relationship with its trading partners, including the United States, that are detrimental to the interests of Canada. 4, the breakdown in the distribution chain and availability of essential goods, services, and resources caused by the existing blockades, and the risk that this breakdown will continue as blockades continue and increase in number. And 5, the potential for an increase in the level of unrest and violence that would further threaten the safety and security of Canadians. Item C, specifying that the special temporary measures that may be necessary for dealing with the emergency, as anticipated by the Governor and Council, are 1, measures to regulate or prohibit any public assembly other than a lawful advocacy, protest, or dissent that may reasonably be expected to lead to a breach of the peace, or to travel to or from or within any specified area, to regulate or prohibit the use of specified property, including goods to be used with respect to a blockade, and to designate and secure protected places, including critical infrastructure. 2, measures to authorize or direct any person to render essential services of a type that the person is competent to provide, including services related to the removal, towing, and storage of any vehicle, equipment, structure, or any other object that is part of a blockade anywhere in Canada, to relieve the impacts of the blockades on Canada's public and economic safety, including measures to identify those essential services and the persons competent to render them, and to provide reasonable compensation in respect of services so rendered. 3, measures to authorize or direct any person to render essential services to relieve the impacts of the blockade, including measures to regulate or prohibit the use of property to fund or support the blockade, or require any crowdfunding platform and payment processor to report certain transactions to the Financial Transactions and Reports Analysis Centre of Canada, and to require any financial service provider to determine whether they have in their possession or control property that belongs to a person who participates in the blockade. 4, measures to authorize the RCM, the Royal Canadian Mounted Police, to enforce municipal and provincial laws by means of incorporation by reference. 5, the imposition of fines or imprisonment for contravention of any order or regulation made under Section 19 of the Emergencies Act. And 6, other temporary measures authorized under Section 19 of the Emergencies Act that are not yet known. Now, I think it's also important for Canadians to appreciate that the Emergencies Act laid out requirements for the government to do certain things during and after the invocation. Now, Section 62(1) of the Emergencies Act says that there needs to be a review by a parliamentary review committee. And it says the exercise of powers and the performance of duties and functions pursuant to a declaration of emergency shall be reviewed by a committee of both houses of Parliament designated or established for that purpose. Now, I'll get back to that in just a minute. The other thing that was required was an inquiry. Now, Section 63(1) says that the Governor and Council shall, within 60 days after the expiration or revocation of a declaration of emergency, cause an inquiry to be held into the circumstances that led to the declaration being issued, and that the measures taken for dealing with the emergency. Now, I think it's important also to appreciate that Justice Rouleau's decision did not provide Canadians with the confidence that they were seeking on both sides of this discussion. A, he made a decision that the very high threshold required was met. However, he did so reluctantly, and he says so in his decision, very reluctantly. He accepted the government's broader interpretation of the Emergencies Act without being given an opportunity to see it. And again, he was troubled by that particular move. It also included in his report that he did not come to this decision easily, and that, interestingly, he states that the facts that he based his decision on were not overwhelming. And to me, the statement that says it all about how Canadians should lack confidence in his decision was that a reasonable and informed person could reach a different conclusion than he arrived at. That does not actually give Canadians much confidence. Now, getting back to the Parliament Review Committee, it was called the Special. Is there a chair, if I may? The commentary over there, if he wishes to participate in this debate, I invite him to do so after I'm done. Thank you.
Point of order, Mr. Speaker. Mr. Chair. This is just another example of the Conservatives pretending to care about security, as we have witnesses here to talk about cybersecurity, for which the Conservatives pretend to care about and clearly don't.
You can grandstand all you want somewhere else.
Grandstand all you want, really. The person who's
Everyone,
grandstanding?
can we just stop for a moment, please? Listen.
The person who's grandstanding was working with Tamara Lynch? Wow.
Yes.
This
Biddle?
is
Mr.
unbelievable.
One
Unbelievable.
moment,
While you're making
please.
witnesses.
Unbelievable right now.
Who's the grandstander?
Mr. Biddle.
Clearly you.
Right now.
Oh, yeah, me right now.
Please, everyone, I'm going to say this once. We had an incident in here before where it was very close to damaging someone's ears by mistake of a microphone just being too close. I've asked at the beginning of this that we do not harm the interpreters. So let's not talk over one another. Everybody will have their chance. Thank you.
Thank you, Chair. I will continue. As I was saying, the Emergencies Act has requirements in Section 62(1) that there is a parliamentary committee, a special joint committee on the declaration of emergency that was required to review the exercise and powers and the performance of duties and functions pursuant to the direct declaration by the government. Mr. Brock and I are fortunate and on that committee and honored to be there, along with colleagues from all parties, along with 4 members of the Senate. And it's interesting that we've met since March of 2022. We have been meeting, and in December 1st of 2022, the committee moved that a interim report be presented to the House. And I think it's very, very important that this committee, who quite possibly will also be having a look at this particular decision by the federal court to examine this overreach by government. And I think it's important that they hear what the committee, what we affectionately call Dead Sea, the Declaration of Emergencies Committee, has to say. The committee directed that the joint chairs be directed to present the following interim report to each House forthwith. Paragraph 1, the Special Joint Committee on the Declaration of Emergency, acting as a Parliamentary Review Committee under Section 62 of the Emergencies Act and pursuant to its orders of reference from the House of Commons and the Senate, adopted on March 2nd, 2022 and March 3rd, 2022, respectively, has been reviewing the exercise of powers and the performance of duties and functions pursuant to the declaration of an emergency order that was in effect from February 14th to 23rd, 2022. Despite a parliamentary secretary urging an interpretation of this mandate such that it, and I quote, does not have to have a retrospective element whatsoever vis-a-vis what happened prior to the invocation of the declaration, the committee, at its meeting on March 5th, 2022, adopted a motion that it would study, and I quote, the options that the Government of Canada utilized during the invocation of the Emergencies Act and enumerated in the proclamation declaring a public order emergency, and that in its study of each option And for the committee's final report, the committee considered the necessity, implementation, and impact of that option. Paragraph 3. To that end, one of the areas of significant interest in the questioning of witnesses throughout the course of the committee's work has been whether the necessary thresholds for the government to declare a public order emergency had been satisfied. Given the particular relevance to the issues which will be addressed in this interim report, the committee wishes to set them out below. Section 17 of the Emergencies Act provides that when the Governor and Council believes on reasonable grounds that a public order emergency exists and necessitates the taking of special temporary measures for dealing with the emergency, the Governor and Council, after such consultation as required by Section 25 of the Act, may by proclamation so declare. Section 16 of the Emergencies Act offers pertinent definitions. Public order emergency means an emergency that arises from the threats to the security of Canada and that is so serious as to be a national emergency. Threats to the security of Canada has a meaning assigned by Section 2 of the Canadian Security Intelligence Service Act, CSIS. A national emergency is, meanwhile, defined by Section 3 of the Emergencies Act. For the purpose of this Act, a national emergency is an urgent and critical situation of a temporary nature that A, seriously endangers the lives, health, or safety of Canadians, and is of such proportions or nature as to exceed the capacity or authority of a province to deal with it, or B, seriously threatens the ability of the Government of Canada to preserve the sovereignty, security, and territorial integrity of Canada, and that cannot be effectively dealt with under any other law of Canada. Finally, in paragraph 8, the Canadian Security Intelligence Service Act defines threats to the security of Canada, sometimes dubbed the CSIS Act threshold, which is imported into the Emergencies Act as follows. Threats to the security of Canada means A, espionage or sabotage that is against Canada or is detrimental to the threat to the interests of Canada, or activities directed toward or in support of such espionage or sabotage. B, foreign influence
Point of order,
activity.
Mr. Chair. While I'm enjoying Mr. Mott's presentation, it occurs to me that because part of this motion is a demand for an order for cabinet confidences and privileged communication, lawyer-client privilege, I question that we have the authority to do this. I would ask whether we could get a ruling whether this motion is in order because it exceeds the powers of this committee.
Can I speak to that? Sure. In the interim report that I am presenting to the committee right now, the committee gets into the law, the rules and procedures of the House, and the authorities of the House of why committees have the inherent right to have access to and ask for these documents. So therefore, the motion is in order because it complies with the requests from other committees and also in compliance with the rules and procedures of the House.
Thank you. Mr. McKinnon, we'll take that into consideration and we'll allow the member to continue.
Thank you, Chair. I will start the threats under the CSIS Act. The threats to the security of Canada mean A, espionage or sabotage that is against Canada or is detrimental to the interests of Canada, or activities directed toward or in support of such espionage or sabotage. B, foreign influence activities within or relating to Canada that are detrimental to the interests of Canada and are clandestine to deceptive or involve a threat to any person. C, activities within or relating to Canada directed toward or in support of the threat or use of acts of serious violence against persons or property for the purpose of achieving a political, religious, or ideological objective within Canada or a foreign state. And D, activities directed toward undermining by covert unlawful acts or directed toward or unintended or intended ultimately to lead to the destruction or overthrow by violence of the constitutionally established system of government in Canada, but does not include a lawful advocacy, protest, or dissent unless carried on in conjunction with any of the activities referred to in paragraphs A to D. The significance of these thresholds was explained to the committee by the Honourable Perrin Beatty, who, as Minister of National Defence, was the sponsor of the bill, Bill C-77, when enacted, which enacted the Emergencies Act, or as the law is called, so-called author, and who appeared before our committee on March 9th, 2022. Mr. Beatty spoke of the choice of the CSIS Act threshold as a deliberate one because of the care that had gone into writing it. He continued, a public order emergency must meet two stringent tests. The first is that to establish the existence of a severe emergency that cannot be effectively dealt with under any other law in Canada. The second is that it must meet a definition of threats to the security of Canada that was drafted to protect Canadians' rights and that specifically provides for lawful advocacy, protest, or dissent. Now, the Honourable David Lametti, Minister of Justice and Attorney General of Canada, appeared before the committee on April the 26th, 2022. When asked whether he had received any written opinions that the Emergency Act should be invoked, he declined to answer on the basis of solicitor-client privilege. Similarly, while claiming solicitor-client privilege, when he was asked what facts or considerations were provided in giving advice in relation to the CSIS Act threshold, Mr. Lametti commented, quote, first of all, the document that we tabled goes through the nature of the various threats across the country, including some of the threats that you were very rightly identified in the way that you framed your question. These, we felt, met the question of serious threats to persons under the CSIS Act definition, primarily that. There is also the economic damage, which could be considered part of the property question. End of that quote. Paragraph 13 of the interim report from the special committee goes on to say, in the face of this claim, the committee on May 31st exercised its authority to send for persons, papers, and records and ordered the production of all security assessments and legal opinions which the government relied upon in determining that A, the threshold of threats to the security of Canada as defined by Section 2 of the CSIS Act, required by Section 16 of the Emergencies Act, had been met. B, the thresholds required by paragraphs 3A or B of the Emergencies Act concerning a national emergency had been met. C, the situation could not be effectively dealt with under any other law in Canada as required by Section 3 of the Emergencies Act. Now, Francois Daigle, Deputy Minister of Justice and Deputy Attorney General of Canada, excuse me, of Canada, replied to this order on June 29th, 2022, writing, and I quote, upon full consideration, it is our department's determination that all legal opinions in our holdings that would be responsive to the committee's order are subject to solicitor-client privilege. He added, I confirm that I am unable to produce legal opinions as sought in the committee's order. At its next meeting on September 22nd, 2022, the committee agreed to deem the evidence, including testimony and documents.
Rappel au règlement, Monsieur le Président.
Thank you. I don't know if Mr. Motz could indicate how much longer he has, because we understand that this motion is to hold back our work on the Act, but we have witnesses here who have interesting information to share with us to help us do our work in examining Bill 26, and the members of committee could benefit from their attendance. And we only have a few minutes left for questions. And according to our schedule, we'll be welcoming other witnesses in the next hour. Mr. Motz, could you please indicate how much more time this takes? Because personally, I believe this is a lack of respect for the witnesses we have with us today.
Mr. Motz, could you give us an indication of how much longer you're going to be?
Well, quite honestly, I don't know. It could be a couple more days. to be honest with you, and I apologize to the witnesses. The issue is that we as a committee, we as government, and government should be seized with is remedying the egregious overreach that they had. So quite honestly, I apologize to the witnesses. C-26 is important, but this to me supersedes that. C-26 has been on the books since what, 2022?
Okay, thank you, Mr. Motz. Can you continue?
Point of order, Mr. Chair.
Yes?
We're trying to hear the response, as you had asked Mr. Motz to provide a response to Madame Michaud's intervention. And all I'm hearing, and I'm sitting right beside my colleague, Mr. Motz, and all I can hear is chirping from Mr. Biddle on the seat, and he's laughing. So this is extremely disruptive to the functioning of
Thank
this
you.
committee, sir.
Okay, everyone, Mr. Motz, could you please continue? Thank you.
Thank you, Chair. I would recommend then that the witnesses today be excused because I have no intentions of ending until I'm finished. Okay, then I guess they say.
Please continue, Mr. Motz.
Thank you, and I apologize to the
They have
witnesses.
10 minutes.
Pardon me?
They can be dismissed in 10 minutes. They're on for the first hour.
Yeah, okay, your first set of witnesses, yes, thank you. Paragraph 14, I'll continue on with the interim report. Francois Daigle, Deputy Minister of Justice and a Deputy Attorney General of Canada, replied to this order on June 29th. Sorry, I read that already. The matter of interpretation of the thresholds in paragraph 16, including the CSIS Act threshold, has lately become a central issue in the proceedings before the Public Order Commission as well. According to a pre-hearing interview held with Commission Counsel David Vigneault, with the Commission Counsel, David Vigneault, who is the Director of the Canadian Security Intelligence Service, stated that at no point did the service assess that the protests in Ottawa or elsewhere constituted a threat to the security of Canada as defined by Section 2 of the CSIS Act, and that CSIS cannot investigate activity constituting lawful protest. Mr. Vigneault emphasized that the threshold imposed by the CSIS Act and under which the service operates is very specific. For example, the determination that something may not constitute a threat to national security under Section 2 of the Act does not preclude a determination that a national security threat under a broader definition or from the perspective of the public does exist. Now, despite February's protests, at no point constituting a threat so as to trigger the service's own investigative thresholds, which under Section 12 of the Canadian Security Intelligence Service Act is based upon reasonable grounds to suspect a much lower legal standard than the Governor and Council's burden under Section 17 of the Emergencies Act of reasonable grounds to believe. Mr. Vigneault recommended to the Prime Minister that a public order emergency be declared based on both his understanding that the Emergencies Act definition of the threat to the security of Canada was broader than the CSIS Act, as well as based on his opinion of everything he had seen to that point. In his public testimony on November 21st, some months later, Mr. Vigneault confirmed he had been given advice encouraging him to apply a broader definition to the Emergencies Act threshold, and he stated, "So when that was first brought up, the fact that the Emergencies Act was using the same words as the CSIS Act to define the threat, so imported into the Emergencies Act, I needed to understand for myself and for, the course of this, what was the implication of that." And that is when I was assured that, it was a separate understanding. And I'm quoting here, the confines of the CSIS Act, the same words based on legal interpretation, jurisprudence, federal court rulings, and so on. There was a very clear understanding of what those words meant in the confines of the CSIS Act. And what I was reassured by is that there was, in the context of the Emergencies Act, there was to be a separate interpretation based on the confines of that act. Now, under cross-examination by counsel of the Canadian Civil Liberties Association, Mr. Vigneault acknowledged that this was the result of a legal opinion he sought from the Department of Justice. Now, this novel interpretation of a broader definition became a theme in the evidence given by ministers and senior officials before the commission.
For the interruption, but we were just wondering about, I was just asking a clarification question on the witnesses on when they leave, if they leave at 8:15 or they continue on, because there may be a possibility when you're finished that we get questions to them. So sorry for the interruption.
That's
my
fine.
mistake.
Thank you, Chair.
Please continue.
So as I was saying, paragraph 21, the committee was seized with this now all of novel interpretation that of a broader definition, and that became a theme of the evidence given by ministers and senior officials. But what's interesting is that when the ministers and some senior government officials were provided their testimony before the Special Joint Committee on the Declaration of Emergency in early 2022, there was no mention from any of them when questioned about that very high threshold that is defined as required in Section 2 of the Act. There was no mention by any of them on this broader interpretation or this broader definition. In fact, it was only when Lametti and Freeland and Mendocino and Trudeau and other government officials
Point of order,
testified at the Rilot Commission.
I'd ask the member to recognize these individuals by their proper titles. As Standing Order 18.
Mr. Motz, can you please?
Sure. Minister Lametti, Minister Freeland, Minister Mendocino, and the Prime Minister Trudeau, and other officials, they testified at the Rilot Commission in the fall of 22. That's the first that we heard that everybody was relying on this broader interpretation, this interesting term. Now, I and many other Canadians are left to wonder why it took so long from when they started providing testimony to the Special Joint Committee on the Declaration of Emergency in April of 2022. Did it take them that long before, and we never heard about it before then? I have some opinions on that, Chair, on why the delay to try and convince Canadians that they acted unreasonably and illegally to invoke the Act by relying on some broader interpretation. One, I don't believe for a moment, not for a moment, that any broader interpretation existed when the Emergency Act was invoked, which they suggest that it was. And if it did exist, it would have been trotted out by the ministers and the government officials at the earliest opportunity. Two, this broader interpretation has remained secret. It's been shrouded behind cabinet confidences. It's been shrouded behind lawyer-client privilege, solicitor-client privilege, and even and it refused to be disclosed to our committee, to the Special Joint Committee of Parliamentary, or on the Declaration of Emergency, refused to be disclosed to Commissioner Rilot, and refused to be disclosed to Justice Mosley in his decision. Now, we all know that this government has a history to operate outside the law. When they are not content to operate within the confines of the law, they attempt to break it. Does anyone remember SNC Lavalin? Or when they try to justify their unreasonable and illegal overreach, they say they had a broader interpretation. What that really means is that this government, this Prime Minister, believes that they are above the law and are not confined by it. That is dangerous, folks. That is very dangerous. And thankfully, the federal court has ruled otherwise in a very important landmark decision. Now, I'm going to go back to the interim report, Chair, if I may. Paragraph 22. The National Security Intelligence Advisor to the Prime Minister appeared before the Commission, the Rilot Commission, on November 17th, 2022. She asserted, and I quote, "My understanding is that the Emergencies Act is assigned a meaning as defined in the CSIS Act, but is not limited by the CSIS Act, and that it can go beyond what the Act says, which is a threat to the security of Canada." When cross-examined by the Canadian Civil Liberties Association Council on December 17th, 2022, on the threshold in the Emergencies Act being tied exclusively and exhaustively to the definition of the CSIS Act, Ms. Thomas answered, the federal government legal opinion is different. For her part, Janice Charette, the clerk of the Privy Council and secretary to the Cabinet, who appeared
Rappel au règlement, Monsieur le Président.
Point of order. I have been listening to Mr. Motz, and it appears to me that the topic that he is discussing today could be referred to another committee on the declaration of situations of crisis, given the reference to the Emergence Act. And Mr. Motz is the chair of that committee himself, so he could move that motion before that committee so that SECU could focus on its study of C26. This is a proposal I'm making I think that it would be far more effective if this issue was studied before the other committee.
While I respect my colleague and that I will tell her that the Special Joint Committee of Declaration of Emergency will be meeting, and I'm sure we'll be discussing this further. This committee also has a responsibility to ensure.
That's very important, what Mr. Motz has just said. The committee is meeting next week?
No.
That's my understanding, and if that's the case, then it would seem to me a bit premature to have consideration of this motion, as well as intended as it might be, if we already have the Emergencies Act Committee meeting next week. To discuss was an important ruling. It would seem to me that we, as a committee, could then be seized with the motion afterwards. But we do have witnesses. It costs thousands of dollars to bring them here. And it would be, I think, wise, as Madame Michaud has said, that we hear from the witnesses that have cost taxpayers thousands of dollars to bring here so that we can improve the legislation that is so important on cybersecurity. And then following the meeting of the Emergencies Act Committee next week, then it would be a good time, I think, to have the discussion around the motion.
Thank you, Mr. Julian. Mr. Motz, do you have any response whatsoever?
Well, I have lots of responses to that, Chair. I'll keep it to this. There are a number of issues that other committees, several committees can also be seized with dealing with the same issue. The joint chairs are meeting next week. There is no full meeting of the Special Joint Committee next week. And it's important to realize that while the focus of the Special Joint Committee is different than this committee deals with national security and emergency preparedness. I don't see a more fitting committee than this one. Thank you, sir.
Point of order. Sometime having passed, I would like to renew my objection to this motion on the basis that I don't believe the committee has the power to deal with it. Mr. Motz mentioned the SNC-Lavalin inquiry. I was a member of the Justice Committee at that time. In order for us to deal with matters pertaining to the SNC-Lavalin inquiry, which involved cabinet confidences and solicitor-client privilege, Cabinet had to explicitly grant access to those, that we as a committee had no power to gain that access. So I would renew my concern that this motion exceeds the authority of this committee. The House itself cannot override Cabinet confidence. It requires an act of Parliament to do that, or the Cabinet itself. So
I'm getting to that.
Anyway, I would renew that. And I know that's an important question. I think it's important that the committee seized with the act itself deal with it. But I also note that this is a pattern of behavior from our esteemed colleagues, because last meeting we were also disrupted by a motion on car thefts, and I'm sure next time it'll be about snow removal in Ottawa. Anyway, I would renew my objection that this is out of order.
Thank you, Mr. McKinnon. What I'm going to do is I'm going to suspend for a couple of minutes and review with the clerk. Thank you. meeting, but before we go any further, Mr. Holland, Mr. Nyman have other further engagements, so I'm going to ask, well, first of all, thank you for coming. Your testimony will be extremely important for C26. And I will ask you this, in case we don't have an opportunity to get you back, and if that's appropriate, I hope that it is from the clerk, but if we could ask for a brief of your notes that you were going to discuss with us today. I would certainly appreciate it that we could put that into the report.
Mr. Chair, my apologies. Would it be also prudent to perhaps ask for permission to send written questions if we have any to the witnesses and have that included in any brief that they provide? Because I think we all had some very important questions that we'd like to have answers to on the record.
Thank you, Mr.
Thank you,
Sheffield.
Mr. Chair.
Yes, good point. So, carry on with the rest of your day. I hope it's as enjoyable as the first hour you spent with us. Now, on to the ruling on cabinet confidentiality. We're still getting some information back on that, so we may have to decide on that a little later. So, Mr. Motz, I'm going to let you continue. But at some point, if we do get the information back to us, then maybe I could have, I may have to do a ruling. So I'm going to, Mr. Motz, if you can continue. Excuse me.
Thank you very much, Chair. I would like to actually to respond with some rulings that exist on regards to whether committees can have access to the documents.
Mr. Motz, if we could just continue with your motion, and at some point, if I do that, then I'd be more than happy to listen to those.
Because there, yeah, if we have to discuss it, there is,
Okay.
there is precedent already.
Thank you.
As a matter of fact, Chair, in the interim report that I'm going through right now from the Special Joint Committee on the Declaration of Emergency, they actually produce, and we talk about, and we'll see it here in a little bit, about the jurisprudence that already exists for access to cabinet conferences and documents, and I'll get to that in just a couple of minutes. I'll pick up on paragraph 25 of the interim report from the Special Committee on the Declaration of Emergency. Natalie Drouin, the Deputy Clerk of the Privy Council and Associate Secretary to the Cabinet, and a former Deputy Attorney General who appeared on a panel with Ms. Charette, offered this perspective under cross-examination. And I quote, "The idea was to make sure that we interpret the incorporation by reference." I guess what I'm saying here is when the legislator adopted the Emergencies Act versus when the legislator adopted CSIS Act, it was for different purposes. The purpose of doing an investigation under the CSIS Act is not the same purpose of triggering or invoking the Emergency Act for public order emergency. In paragraph 26, the Honourable Bill Blair, President of the King's Privy Council for Canada and the Minister of Emergency Preparedness, told the Commission on November 21st, 2022, and I quote, "For the purposes of the Emergencies Act, that definition, I believe, has a broader application that is contained within that definition." Marco Mendicino, Minister of Public Safety, asserted that the threshold was met in the broader interpretation of the law. Now, I'm off the report here, Chair. I'm noticing a theme developing between the testimony of ministers. Meanwhile, the Honourable Dominic LeBlanc, Minister of Intergovernmental Affairs, Infrastructure and Communities at the time, who also appeared on November 22nd, assured the Commission that my colleague, and I quote, "My colleague David Lametti will be here tomorrow. He'll be, I'm sure, to speak directly to the legal test that the government was using and concluded when the Governor and Council made the decision." Mr. Lametti, end of quote. Mr. Lametti, for his part, when he appeared on November 23rd, 2022, attempted to square the circle on the interpretation of the threshold, and it stated, while it is the same standard of the same magnitude, the interpretation of that standard is being done according to a wider set of criteria by a very different set of people with a different goal in mind, and that goal is given by the Emergencies Act and not the CSIS Act. He later clarified, and I quote, "The threshold, as applied, as you've seen in testimony before this Commission, has evolved. The rules of thumb for interpreting that have evolved as well. For the purpose of that act is very different. The very same words will have not a wider meaning, but will have a wider area of interpretation according to the very structure of the Emergencies Act. And I think that it is the interpretation that I would put to you as the one that best bears out in practice and is correct. End of quote. Unfortunately, though, when he was asked to explain the assurances which Mr. Vigneault spoke about and which are quoted above, Mr. Lametti was unable to answer. The Right Honourable Justin Trudeau, Prime Minister, was the final witness before the Commission on November 25th, 2022, and he also was asked about the CSIS Act threshold issue. For his part, Mr. Trudeau explained, and I quote, "The use of the definition in the CSIS Act, as I said before, has two very different contexts from the use of it by CSIS and the use of it in invocation of a public order emergency. The context is different, the purpose is different, the decision maker is different, the requirements around it, the inputs are different." End of quote. Now, just a sidebar, Speaker. Back in my days, if I was to listen to testimony in a court of law, and I heard a number of people providing testimony, and they all sounded very much alike, I certainly would have the impression that they had got their heads together in cahoots to compare their testimony pre-trial. Anyway, paragraph 33. Suffice it to say, the outstanding issue about the novel and what some like the Canadian Constitution, the Canadian Civil Liberties Association have called creative legal interpretation has become a very salient issue in the issues before the committee and the Commission. Indeed, it has become an irritant to more than just some of the members of the committee. Commission Counsel Gordon Cameron remarked at the conclusion of Mr. Lametti's examination that the Commission had attempted to find a way to lift the veil that has made such a black box of what has turned out to be a central issue before the hearing, lamenting that, and I quote again, "We just regret that it ends up being an absence of transparency on the part of the government in this proceeding." I think powerful words by the council here, Chair. Paragraph 35 of our interim report. The Honourable Paul Rouleau, the Commission's Commissioner, indeed added the observation, and I quote, "As was mentioned by Commission Counsel, there is an issue of reasonableness of it, and I'm having a little trouble, and I don't know if you can help me. How we assess reasonableness when we don't know what they were acting on? And do we just presume they were acting in good faith without knowing the basis or structure with which they made that decision? And you know of which I speak." And as a sidebar, again, Chair, unfortunately, Mr. Rouleau, Justice Rouleau, accepted the novel interpretation by the government without actually seeing it, which I think is a black mark on his work on the inquiry. Paragraph 36. Essentially, it boils down to an argument of just trust us as to the justification for a proclamation. And I think I want to go back and remind my colleagues around the table that this interim report was presented by the special joint committee of all parties of the Declaration of Emergency. That is the opinion so far for the last half hour, that the report that was submitted. So it's not just me talking here. Essentially, it boils down to an argument of just trust us as to the justification of a proclamation of a public order emergency, which allows the federal cabinet both to legislate by decree and to do so on matters let me try that again. To legislate by decree and to do so on matters which are normally a matter of provincial jurisdiction. 37. Why the government would take such a course of action and remain so opaque is on this area begs many questions, invites a lot of speculation, and prompts a search of other evidence in order to draw inferences. For example, as other documents adduced before the Commission came to light, it became apparent that Mr. Lametti may have long been an advocate for strong action up and including the invocation of the Emergencies Act. Notably, on the third day of the protests, that's critical, on the third day of the protests, he texted his chief of staff, "Do we have a contingency for these trucks to be removed today or tomorrow or Tuesday. What normative authority do we have, or is some order needed? EA, question mark. He then, on February 2nd, texted Mr. Mendocino, and I quote, "You need to get the police to move and the Canadian Armed Forces if necessary," end quote. Paragraph 40. Meanwhile, Mr. Lametti's interventions at a February 5th, 2022 meeting prompted Royal Canadian Mounted Police Assistant Commissioner Mark Flynn to remark to his colleagues in a group chat, and I quote, "When the AG talks like this, we better get our own plan going." Minutes later, in the same group chat, RCP Commissioner Brenda Lucki wrote, and I quote, "I need to calm down. I need to calm him down." Then contemporaneously, with Assistant Commissioner Flynn's remark about Lametti, added, "Okay, so calm is not in the cards." Paragraph 41. During the 10 minutes immediately following Mr. Lametti's intervention, which had caused such a stir, Commissioner Lucki sent Ontario Provincial Police Commissioner Thomas Carrick several messages, including, and I quote, "Between you and I, the Government of Canada is losing lost confidence in OPS, meaning the Ottawa Police Service. We got to go get to safe action and enforcement." She also said, "Because if they want to go to an Emergency Measures Act, you may be brought in to lead, not something I want." Next paragraph. "Trying to calm them down, but not easy when they see cranes, structures, horses, bouncy castles in downtown Ottawa." Next quote, "Any suggestions for calming them?" Referring back to ministers in cabinet. Paragraph 42. "Could it be that the Attorney General and possibly others of his cabinet colleagues were so committed to the invocation of the Emergencies Act that any legal advice was molded to shape the desired answer?" Certainly, doubts about the strength of the case for invoking the Emergencies Act are acknowledged by Ms. Charette on her February 14th, 2022 memorandum to Mr. Trudeau recommending the declaration of a public order emergency. And she says, and I quote, "In PCO's view, this fits within the statutory parameters defining threats to the security of Canada, though this conclusion may be vulnerable to challenge." End of quote. As we can see, Chair, it certainly has been vulnerable to challenge. These issues implore the committee to revisit its earlier orders for production of the legal opinions which the government relied upon, both for the benefit of the committee's work, but also that the Public Order Emergency Commission, as Mr. Beattie had explained to the committee when he appeared on March 29th, 2022, and I quote, "If you are looking at the actions taken by the government flowing from the invocation, and if you uncover evidence indicating that the invocation of the Act was inappropriate, then everything that flowed from it was inappropriate as well. It seems to me that they're part and parcel of the same thing." I think it's important that we read that again. If you are looking, and this is Mr. Beattie, who actually crafted the legislation back in the mid-'80s. If you're looking at the actions taken by the government flowing from the invocation, and if you uncover evidence indicating that the invocation of the Act was inappropriate, which has since been done, then everything that flowed from that that was inappropriate as well. It seems to me that they're part and parcel of the same thing. And here gets the crux of the transparency, Mr. Chair. It is incumbent for full transparency for there to be full disclosure of the legal opinions which the government relied upon in declaring the first ever public order emergency in Canada, so that we can determine whether it was appropriate or inappropriate. We have questions which we want answered. And this is a committee of Parliament talking to with the report being sent to Parliament. The preeminent right of committees to obtain answers to their questions. This may be of importance to Mr. McKinnon. The preeminent right of committees to obtain answers to their questions stems from the House's authority to institute and conduct inquiries and the power to send for persons, papers, and records. These parliamentary privileges are rooted in the preamble and Section 18 of the Constitution Act of 1867 and Section 4 of the Parliament of Canada Act. These powers were delegated by both houses to the committee meaning the Special Joint Committee of the Declaration of Emergencies Act, through the House's orders establishing that committee. Now, given their constitutional nature, a committee's powers, not just the Special Joint Committee, but all committees' powers, supersede statutory law and other privileges, such as solicitor-client privilege. With regard to papers, there is no limit on the types of papers that can be requested. The only prerequisite is that the papers actually exist in hard copy or electronic format and that they are located in Canada. They can be papers originating from or in the possession of governments or from the private sector and civil society. This is from the, Mr. Chair, for the clerk and your reference. It's the House of Commons' Practices and Procedure Manual, page 984, and also the Senate Procedure and Practice, pages 199 and 200. In practice, Chair, committees may encounter situations where the authors of or officials responsible for papers refuse to provide them or are willing to provide them only if certain portions have been removed. Public servants and ministers may sometimes invoke their obligations under certain legislation, such as the Privacy Act or the Access to Information Act, to justify their positions. As noted in the House of Commons Procedure and Practice, these types of situations do not limit the power of committee to order the production of papers and records. Now, I quote from that document, "No statute or practice diminishes the fullness of that power rooted in the House privileges unless there is explicit legal provision to that effect or unless the House adopts a specific resolution limiting that power. The House has never set a limit on its power to the order of the production of papers and records." And this is from Speaker Milliken in page 985 of the debates from June of 2011, and then Speaker Rota's ruling on June 16th, 2021 as well. Similarly, as noted in Erskine, May 25th at paragraph 38.32, the same power to send for records is not considered subject to statutory exception in the United Kingdom House of Commons either. And I quote, "There is no restrictions on the power of committees to require the production of papers by private bodies or individuals, provided that such papers are relevant to the committee's work as defined by its order of reference. Select committees may have formally ordered papers to be produced by the chairman of a nationalized industry and a private society. Solicitors may be ordered to produce papers relating to a client, and a statutory regulator has been ordered to produce papers whose release was otherwise subject to statutory restriction." Excuse me for a sec, Chair. Paragraph 51 of the interim report goes on to say, "In recent years, there was a very high-profile instance of the United Kingdom House of Commons insisting on the production of government legal opinions when, amidst the Brexit debates, on November 13, 2018, it adopted a motion requiring the production of any legal advice in full, including that provided by the Attorney General on the proposed withdrawal agreement on the terms of the UK's departure from the European Union, including the Northern Ireland backstop and framework for a future relationship between the UK and the European Union," end of quote. On December 3, 2018, the Attorney General of England and Wales presented to Parliament a command paper which purported to describe the overall legal effect of the European Union withdrawal agreement on November 25, 2018. On the same day, he made a statement to the House. Neither the command paper nor the statement made reference to the resolution of November 13, 2018, and the command paper did not purport to be a return of the resolution of the House. Later that day, after representatives of 5 opposition parties alleged the government had not produced the documents required, Mr. Speaker Burkow ruled that there was a prima facie contempt. The House of Commons on December 14th adopted the following motion, and I quote, "that this House finds ministers in contempt for their failure to comply with the requirements of the motion for return passed on 13th of November 2018 to publish the final and full legal advice provided by the Attorney General to the Cabinet concerning the European Union's withdrawal agreement and the framework for the future relationship and orders its immediate publication." In response to the UK government, produced a complete, unredacted copy of the Attorney General's legal advice the next day. The Attorney General later said that he had complied with the order of the House on December the 4th out of respect of the House's constitutional position. The House has power to call for papers, procedure, and practice. Now, the Special Joint Committee on the Invocation of the Emergencies Act wishes to draw attention to what appears to be a possible breach of privilege in relation to the production of legal opinion response to our order of May 31st, 2022, and recommends that the House take such measures as deemed necessary. Further, the committee makes the following recommendation: that in order to issue for all legal opinions which the government relied upon in determining that A, the threshold of the threats to the security of Canada is defined by Section 2 of the Canadian Security Intelligence Service Act, required by Section 16 of the Emergencies Act, had been met. B, the thresholds required by paragraphs 3A or B of the Emergencies Act concerning a national emergency had been met. C, the situation could not be effectively dealt with under any other law in Canada and required by Section 3 of the Emergencies Act, provided that D, these documents shall be deposited with the Office of the Law Clerk and Parliamentary Council in both official languages within 14 days. A copy of the document shall be also deposited with the Office of the Law Clerk and Parliamentary Council in both official languages within 14 days, with any proposed redaction of information which, in the government's opinion, could reasonably be expected to compromise national security. The Office of the Law Clerk and Parliamentary Council shall promptly thereafter notify the Speaker, who shall forthwith inform the Senate of the House, the Senate or the House, as the case may be, whether it is satisfied the requested documents were produced as ordered, provided that the Speaker shall, if the Senate or the House, as the case may be, stands adjourned, lay the opinion of the Office of the Law Clerk and Parliamentary Council upon the table pursuant to Senate Rule 14.1.6 or House Standing Order 32.1, as the case may be. G, the Office of the Law Clerk and the Parliamentary Council shall transmit to the Public Order Emergency Commission a copy of their unredacted documents referred to in paragraph D forthwith upon receipt. H, the Speaker shall cause the documents redacted under paragraph E to be laid upon the table at the next earliest opportunity, and after being tabled, they shall stand referred to the Special Joint Committee on the Declaration of Emergency. And I, representatives of the Office of the Law Clerk and Parliamentary Council shall discuss with the committee at an in-camera meeting to be held within a month of the redacted documents being tabled, whether it agrees with the redactions proposed by the government. And J, the committee may, after hearing from the Office of the Law Clerk and Parliamentary Council, accept the proposed redactions or reject some or all of the proposed redactions and request the production of those unredacted documents in the manner to be determined by the Special Joint Committee, and that the clerk be directed to notify the Public Order Emergency Commission of the adoption of this order, that a message be sent to the House and acquaint itself accordingly. So you can see by that information, Mr. Chair, that there's certainly some precedent to allow for documents to be presented to committees, and even if they are behind cabinet conferences. Now, as I move forward, I think it's important to get a sense of what the response has been from after the and as we move on, I'm going to get into the poignant points of the decision from Justice Mosley, but I want to kind of go through some of the comments that have been made by by the media in response to. And I'm just going to pick out a few of the common points that have come through. In Paul Wells writes, on the 23rd of January, the day of the actual decision by the federal court, that there will be all kinds of claptrap written about this decision, some of it from people who believe themselves to be friends of this government. So it's worth emphasizing that this challenge succeeded thanks in part to good lawyering from career civil liberties defenders who went to fancy law schools and cannot be dismissed, as this government glibly dismisses far too many of its critics as tools of Donald Trump. He goes on to say, but I believe it could be addressed. And my opinion on all of this is pretty far from any of the overheated schools of thought that usually debate the convoy and its aftermath. I didn't really much like the convoy, unless as it went on. But I believe it could be addressed, and to a great extent, it was addressed using ordinary law and ordinary police power. I think Trudeau's government, operating under extraordinary pressure, and in particularly under heavy commercial pressure from the United States, decided to break the emergency glass
Point of order,
and
Mr.
grab
Chair.
the little hammer. I didn't like the precedent
Point
that
of
set,
order.
so I'm happier with Mosley's ruling.
Put a finger where you're reading from.
Pardon me?
Put a finger where you're reading from to get back to it.
Thank you.
Mr. Chair, I just think it's important to point out that while Mr. Motz reads from newspaper articles, we actually have witnesses waiting to appear on the issue of cybersecurity who have taken the time out of their busy day to actually come and provide their expertise while Mr. Motz proves his reading skills and simply reads newspapers.
Thank you, Ms. O'Connell. Mr. Motz, you continue, please. And
Thank you very kindly.
try to keep it as localized as possible.
Another
to the
point of
issue.
order, please?
Yes.
I would also request that even though Mr. Motz is reading from articles, that he should give due recognition of the titles of the people.
I'm reading what the authors wrote, so I'm not going to change what they wrote.
Well, I think you can interject some respect there. Thank you.
So that's what, unfortunately, that's what happens when you interject yourself, whether, I won't get into the.
Let's not get into a debate,
Yeah.
Mr. Motz.
Thank you.
Please, just to make sure you identify the articles and
This
the
is a
authors.
national,
Point of order.
Mr. Shipley.
Sorry, but he was reading a quote. Do you, Chair, expect him to change the quote? I'm just asking.
Point of order.
Mr.
I'm
Shipley,
asking the Chair.
hold on, guys. I just said to Mr. Shipley, I just said to Mr. Motz that if he just read the article and identify the paper that it's coming from and the author. That's
We're
it.
good with that, okay. So he doesn't have to change it to
Thank
change
you.
the titles. Thank you.
Yes, Mr. Julian.
Thank you, Mr. Chair. We have spent thousands of dollars to get these witnesses here. This is an important bill on cybersecurity. I'm wondering through you if you could ask Mr. Motz to pause the debate, and we can come back to it at the next meeting, but allow the witnesses to provide that testimony. I don't understand why we would take thousands of dollars of taxpayers' money to invite witnesses to testify and not hear them on an important cybersecurity bill.
Thank you, Mr. Julian. Mr. Motz, you heard the question from Mr. Julian. Could you?
yes. I know he's an NDP colleague, but I actually like Peter, and I would, if we could adjourn this debate, I would certainly, on this motion, and for the time that we have remaining, go to C-26. I'm fine with that to honor his request.
So let's call it.
No, I did
Yes,
not.
you just
I
did.
said to suspend this conversation.
You said
on-
adjourn.
I did not move a motion. I'm agreeing with him to say, let's get the C-26 for the remainder of our meeting today, and I'll pick this up at next meeting. Thank you very much.
Agreement of the committee? Agreed? Suspend. Yep. Okay, so our witnesses.
I will need a few minutes to set up the second.
Okay. Can you give us, we'll suspend for 2 minutes just while our witnesses get in place? Conference Canadian Constitution Foundation, Joanna Baron from Toronto, Executive Director. In person, Center of International Governance Innovation, Aaron Shaw, Managing Director and General Counsel. And Privacy and Access Council of Canada, Sharon Polsky, President. So welcome. And if you could do an introductory, whoever wants to start, that'd be appreciated.
I'm happy to start. Good morning. My name is Joanna Barron. I'm Executive Director of the Canadian Constitution Foundation. And I am happy that I did not cost taxpayers thousands of dollars to appear by video conference this morning. Shall I go into my remarks?
Please.
Oh,
yes.
Thank you very much. I'm here, of course, to address Bill C-26. This is a bill that grants the government sweeping new powers. And we have concerns that there is no accompanying regime of checks and balances to safeguard rights. As a legal charity dedicated to defending fundamental freedoms, I'd like to speak to some of these points. As drafted, the bill threatens to undermine our privacy rights, as well as the principles of accountability and due process, which form the bedrock of our democracy. The powers proposed by the bill risk impacts on the charter-protected rights of privacy, right against unreasonable search and seizure, freedom of expression, and equality. And of course, we understand that cybersecurity is a huge imperative. We do not believe or accept that cybersecurity ought to come at the cost of civil liberties. The proposals that the CCF is pleased to sign on to, along with other civil liberties groups, align with other international approaches, such as those taken by our partners in the UK and Australia, both of which place a far greater emphasis on proportionality, accountability, and privacy rights. The issues raised by this bill apply to Canadians in our everyday lives. For example, under the bill, if someone's device or smart appliance were hacked and used to target a government website, the federal government could order their telecom service to be shut off in an order that could be kept secret from the public, and the affected person or business would never even know that it was the government that ordered their service disconnected. The bill also does not provide a mechanism for restoring service to individuals or businesses who lose it, which obviously interferes with basic livelihood in 2024. I'll speak to a few substantive issues. The bill raises the specter of new and pervasive surveillance obligations. It empowers the government to secretly order telecom providers to, and I quote, do anything or refrain from doing anything. This opens the door to new obligations on private companies, as well as to other risks of encryption standards, which poses an inconsistency with privacy rights. There are no guardrails in the bill. The bill lacks proportionality, privacy, or other checks which might constrain abuse of the new powers it grants the government. And these are powers that are backed by steep fines and even potential imprisonment for non-compliance. So we propose that adding a proportionality test and an obligation to consult with experts to help ensure that the minister does not use small problems to justify disproportionate actions. Adding a proportionality requirement will bring Bill C-26 more in line with our counterparts in Australia and the UK. I'd next like to talk to some privacy concerns. The bill empowers the government to collect broad categories of information from operators, and it may be enabled to obtain identifiable personal data, which can be distributed to domestic and other, perhaps foreign organizations. The bill does not have a mechanism for limiting what Ottawa can do with the data it collects or specified periods for data retention, as well as measures to deal with possible negligence with people's data. We find that the secrecy provisions undermine accountability and due process. The bill enables the government to shroud its orders in secrecy with no mandatory public reporting requirements. Of course, we understand the need for confidentiality, but the public ought to have a sense of how these powers are being exercised to one effect if our elected decision makers are to be held to account. This excessive secrecy has clear implications for the freedom of expression rights of the public, as well as the media, as protected by Section 2B of the Charter. finally, I'd like to speak about the use of secret evidence in court, which is authorized by Bill C-26. Even if security orders made under the Act are subject to judicial review, the bill could restrict applicants' access to evidence, which is a violation of the rules of natural justice. The minister is permitted to request that some of the government's evidence be heard in camera solely by the judge. The applicant for the review is not permitted to access information that, this is from the statute, in the judge's opinion would be injurious to international relations.
Thank you, Ms.
national
Barron.
defense,
Ms. Barron,
or
we're scooting over time here, and we're running short overall, so I'm sure
apologize.
yeah, no, that's fine. Okay, it's up to Ms. Pawlski or Mr. Shull, whoever wishes to go next, please.
Thank you, Honorable Chair, members of the Standing Committee, ladies and gentlemen. I thought what I could do with my brief time today is offer you a little bit of advice and make you a good faith offer. So what I'm going to do is maybe make a general observation. I think the bill is pretty good as it stands. I think it's a pretty good step forward. And obviously there's lots of advice in terms of what has been provided to this committee, and most of it's really good. So I'm not going to do a clause-by-clause takedown of the bill, but I'm going to use a quote from former U.S. Defense Secretary Robert McNamara, which is, never answer the question that's asked of you, answer the question you wish you were asked. I wish I was asked the question that the honourable member from St. Jean asked earlier this week, actually concerning incentives around cybersecurity. So the advice I'm going to offer to you is I think you can make a change to this bill that will do a lot of good. And it's to create a tax incentive for small and medium-sized enterprises to implement something called the baseline controls or the CyberSafe standard. Why this matters is SMEs are like 98% of our economy, and they appear nowhere in this bill. Also, the CyberSafe standard that was put in place by the CSE is pretty good. If most SMEs put in place those controls, chances are they'd be just fine, because what I can tell you about cyber criminals is that they're lazy and that there's another sucker just down the street. And so if we harden our SMEs through these controls, chances are they'll be just fine. So if we put in place a tax incentive to encourage cybersecurity compliance rather than a hammer to punish non-compliance, I think that would get us a far way to doing so. Obviously, the reasons behind this, it can promote participation, it can strengthen national security, create tons of economic advantage, because less companies would be down. Less companies in our supply chain would be down. And so the taxable revenue would likely be up at the end of the year. Now, I appreciate that this bill has to get through the House of Commons, and while I'm nonpartisan, I appreciate you all have a job to do. And I think partisan politics are a healthy part of our democracy, so I encourage the types of discussions that you're all having. But thinking through the politics of it, the Liberal Party, I mean, they would see alignment with their innovation and economic development agenda. The Conservative Party, they would see the fiscal responsibility and the national security aspects of what I'm talking about, I think, to be favorable. The New Democrats, the New Democratic Party would appreciate the support for our core communities, which are built on SMEs. The Bloc would recognize the protection that this extends to Quebec's economic interests, and the Green Party, I think, would endorse the sustainable approach to securing our digital future. So that's my advice, is put a tax credit in for SMEs to put in place the CyberSafe standard. My offer to you is this. I work at one of the best think tanks in the world. If it's of service to this committee, I'm happy to provide draft language of what I think that could look like. And then I'm happy to convene some of our experts to offer further advice or answer any questions that you have. I think you all have a tough job to do. And the last thing I'll say, and then I'll be quiet, Mr. Chair, is probably something you all don't hear enough, is thank you. Thank you for your work. I mean, being a member of Parliament is a tough job. It's demanding, and I don't think most people appreciate how hard you all work. So notwithstanding the politics, my job is to provide advice on policy without politics, and I hope I've done so. Thank you, Mr. Chair.
Thank you, Mr. Shull. I appreciate your comments. Ms. Pawlski, please.
Thank you very much, and thank you all for inviting me to appear on behalf of the Privacy and Access Council of Canada, an independent, nonprofit, nonpartisan organization that is not funded by government or industry. Our members, like everybody in this room and the rest of us who use the internet, can thank Sir Tim Berners-Lee, whose brainchild became the web we know and love, or love to hate. It's a source of news and views that might be at odds with our own, where we can freely find and share information, and it is that very freedom that is now under threat with democratic governments leading the charge. Canada's government has said that controlling internet content is vital to protect democracy and social cohesion, and pointed to the January 6th insurrection in Washington, D.C., that by all accounts was organized online. And it's crafted several laws to protect us from potential danger, of course, C-26 being one of them, to provide a framework for the protection of the critical cyber systems that really are vital to national security and public safety. Bill C-26 allows Canada to take strong action against threats to its security of its telecommunications sector, but also so very much more. To start with, it applies to 6 critical infrastructure sectors, but that is just the start. As Ms. Barron referred, any service system and class of operators can be designated as a vital service or system, so every company is at risk of falling under the bill's sweeping powers and being required to do or refrain from doing anything they are ordered to do, including create backdoors and break encryption or go on a fishing expedition to find whatever information the government wants, including what's in your emails and your texts, your cell phone and vehicle locations, purchasing information, donor details, so that it can make an order. And the order will be secret until the target realizes something's up, because just disclosing the existence of orders made under this bill will be illegal. With a nod to Eastern European regimes 100 years ago, this bill lets the minister compel any person under threat of punitive fines to provide any information within any time, subject to any conditions that might be specified, or authorize anyone to enter and seize any information in systems, but without the checks and balances that are a mainstay of democracy. Notably, there is no requirement for those timelines or conditions to even be achievable, and the bill does not limit compelled information to corporate or operational, and there is reason for that, but it provides a dragnet for unsupervised collection, use, and the broad disclosure of personal information, threatening individuals' privacy, and making it impossible for organizations to comply with privacy laws or provide accurate responses to access to information requests. Sadly, the bill makes no mention of consulting the Privacy Commissioner to ensure personal information is adequately safeguarded, and while the bill specifies corporate information may be designated as confidential, it offers no such consideration for personal information. The bill's vague language opens the door to telcos and ISPs being given unreasonable orders to spy on or deny service to any person, company, or group whose conduct or commentary the government deems a threat to the security of Canada. To encourage voluntary compliance, the penalties are steep and unaffordable by all but the largest of organizations, and in the manner of Salem witch hunts, anyone who fails to pay the penalty or dispute the notice, and anyone who does pay, is also deemed to have committed the violation. Either way, businesses pass their costs and fines along to consumers, so penalties will reduce competition by eliminating organizations that can't afford the fines, and consumers will end up covering the penalties paid by those that are large enough to afford them. Incentives like that can be a strong motivator. Some would call it coercive, since companies and people are eager to retain their hard-earned money and avoid fines, and they're easily nudged to simply do as they're told, while the government will be shielded from claims of overreach, since it won't be the government, it will be the organizations voluntarily complying with orders that will be the ones violating charter-protected freedoms. In our view, allowing Bill C-26 to become law in its current form and granting elected representatives and unelected bureaucrats the overbroad and unaccountable authority will further undermine public trust in the government, public service, and federal institutions, and further foster a technocracy built on Sir Tim Berners-Lee's brainchild. Canadians deserve better, and we are happy to help in providing additional information and suggested amendments.
Ms. Polsky, right on time. Before we start questions, and we're going right into questions, with the time we have, it's going to be 4 minutes each, and we're starting with Mr. Shipley, please. And it's a hard stop on your questions.
Thank you, Chair. I would like to start with Ms. Barron. You just it looked like you were coming near the end of yours. I want to give you a little bit of opportunity to see if you wanted to finish your opening remarks here first.
I apologize. I was muted. I really appreciate that. What I wanted to mention is that I think it's important that the bill be amended to allow a procedure for special security cleared advocates, which are used, of course, in the immigration context. And we've actually suggested they should be allowed in the Emergencies Act context, just to follow up on a conversation today. So a provision for security cleared advocates is an imperfect solution for due process, but they would be allowed to test the evidence brought in these secret hearings. They have top secret clearance, but to allow a minimal check procedurally on applicants' rights.
Thank you. In your opening remarks, I was scribbling down some notes as best as I could. You mentioned about service being cut off. Could you expand on that? Because I didn't quite get all that. Was it individual service? You mean their cell service, or was that companies? What did you mean by that? And can you expand on those points?
Well, because the bill allows the minister to do anything or prevent a person from doing anything, the understanding is that this could allow the government to issue an order to a telecom provider to cut off internet service of companies or private individuals. For example, if they believed or even had evidence that their service was compromised and being used to target a government website or for some other improper procedure.
Thank you. You also mentioned you had some surveillance concerns and said that there's some needs for some guardrails from these abuse of new powers. Can you expand on what those surveillance concerns are?
Yeah, well, again, the bill empowers the government to secretly order telecoms to do anything or refrain from doing anything, which raises the clear specter of imposing surveillance obligations on private companies, as well as possible weakened encryption standards.
Thank you. And I'd like to ask Ms. Polsky, and I hope I said your last name properly there. If I didn't, I apologize. You mentioned that this applies to 6 critical infrastructure areas. We have had some other people saying that it's not enough. When in your opening remarks, do you figure that 6 is too few or too many?
I think as it is now, and actually as the critical infrastructure categories were defined just after September 11th, anything could be construed to fall under one or more of those categories. They're very broad and not really very well defined. Anything has economic value. Many things have implications for transport. I think it's not a matter of defining the categories so much as looking at what the threats are, what the implications of the legislation as drafted could be.
Thank you. And just a quick follow-up. You mentioned about the minister control too, but I believe you said there's permission for them to enter and seize, and there needs to be some checks and balances. Did you want to expand on that statement?
Certainly. From our understanding, the legislation allows for anybody to be appointed as an inspector and has power to enter any premises short of a residence without a warrant. And they can seize anything, no limit. And there's no requirement that it be related to a certain complaint or concern. It's open-ended.
Done. Thank you. We're going to move on to Mr. Shefke, please.
Thank you very much, Mr. Chair, and I'd like to add my thanks to the witnesses for being here today in person and virtually. Mr. Schul, I want to start with you and first thank you for using your opening remarks to provide solutions and ideas. In fact, that's why we're here. We're looking for ways to improve on C-26, ensure that we have a bill that protects Canadians while also ensuring that we protect their constitutional rights. And so my first question for you is with regards to mandatory reporting for affected sectors and whether there's a cybersecurity incident. Why is it important that we have that mandatory reporting?
Well, two or three different reasons. First is that it allows CSE or the Cyber Center to take action. And the problem you have is many of the critical sectors are targeted by state-level actors. And I got news for you. If someone swipes in with a military badge on the other side and goes after a civilian structure, they're going to get in. Right, and so, and I know you can take a briefing from CSC on this, but adversarial states are loading up our critical infrastructure with malware as they're pre-positioning it in the case of a conflict, and so that's bad. And so, to the extent that we can increase the efficacy of government agencies on those networks, we should when something bad happens. Second point is it increases visibility across the network. And third, it allows for the spreading of best practices. If there's an exploit that's used, let's make sure it only gets used once.
Thank you for that. My next question I'm going to ask to Ms. Polsky as well as Ms. Barron, and I'll ask you for responses each. If you can keep them quick, that'd be great. I only have 4 minutes. The first is, would you support the inclusion of a reasonableness standard for both cybersecurity directions and telecommunications systems order? And I'll start with you, Ms. Polsky.
The short answer is yes. It needs to be there.
Thank you. Ms. Barron.
Yes. Yeah. Given that it's a normal, robust reasonableness standard, absolutely.
You. Next question for both of you is, would you support clarifying the scope of ministerial order making power by changing wording found in the bill from do anything to do a thing specified in the order? It currently states do anything. Would you support a change to do a thing that is specified in the order itself?
To suggest do a thing that's specified in the order, that we could hope that that would limit it. Unfortunately, in my experience, and from discussions with law enforcement, with members of the bar and bench, and frankly, some of your colleagues, they admit they don't get it. They don't understand it. So, and I'm talking about technology, artificial intelligence, the implications and the unintended consequences of some of the legislation that is being promoted now. So to say limit it, when the judges themselves don't have to have any education about these matters, they can be presented with whatever you want and be bamboozled, really and truly.
Ms. Barron.
I would say that also sounds like it would not build in any sort of concept of proportionality to do anything specified in the order. I do like it better than do anything or refrain from doing anything, but it sounds like it could also be quite unmoored.
The chair looks very generous today, so I'm going to ask one more question, if I may.
30 seconds.
Would you support establishing a list of factors that must be considered before an order can be issued? And I'll turn it over to you, Ms. Polsky.
Yes, but who's going to create that list? And what are their motives?
Thank you. Ms. Barron.
Yes, assuming that broad consultation of stakeholders will precede that.
Thank you both. Thank you, Chair.
Thank you. Ms. Michaud, please.
Merci, Monsieur. Thank you, Chair, and thank you to the witnesses for using your precious time to be here with us to help us with the study. Mr. Schull, I really liked your introduction. You were straight to the point, as we say, and I much appreciated that. I have talked to a few groups outside of this committee, and the majority of them believe that, yes, this is a good step forward, and on the whole, this bill is good. They have two main criticisms. One, that you give a lot of power to the government, to certain ministers with orders or directives, instructions, and also the severity of the sanctions. You talked about tax incentive. I've understood that to be what it is. It's a tax incentive for businesses that would put in place a security framework rather than grow the route of sanctions. You've turned things around to enable businesses to participate on a voluntary basis, but to ensure compliance and also the protection of privacy. Could you elaborate further, please?
Mr. Chair, that's a great question. So what I'm talking about is small and medium-sized enterprises and protecting them as opposed to critical infrastructure providers that are defined in the Act. It allows you to take federal jurisdiction by using your tax power and protect the companies that make up the bulk of our economy. Critical infrastructure is super important because, well, it's critical. And if it goes down, people are going to know about it. But the problem we've got is many companies that are not critical infrastructure providers are being robbed through ransomware. And enough is enough, and the tax credit would provide that incentive. It's a good question, Mr. Chair.
So would you replace the sanctions with these tax incentives? Would you leave the sanctions in place? What is your suggestion?
in place. Your point is a good one. Like there's almost an internal inconsistency in the bill because they say, well, the administrative monetary penalties are to encourage compliance, but they can be up to $15 million a day, right? So this is not meant to be punitive, but we can fine you $15 million a day. Sounds pretty punitive when you think about it that way. All that to say, I would leave the penalty structure in place as currently defined for critical infrastructure providers. I would add on the incentive structure for small and medium-sized enterprises that do not fall within the statutory definition of critical infrastructure providers.
Thank you. And you talk about SMEs. Some have concerns regarding all of the additional administrative burden, and that's evolving a lot in this area of cybersecurity. If they're dealing with an incident, the deadlines within which they have to communicate information to the government, and of course also the confidentiality of that information. So they have concerns about that, and I have not managed to get many answers from the government to reassure these businesses. What can we tell these businesses? Are they right to have these concerns?
Great question, Mr. Chair. I mean, I'm a little bit personally unconvinced by the regulatory burden argument. All we're saying is that all the bill is saying is that if you work in critical infrastructure, you have to have a plan in place. You have to have a cybersecurity plan. And so the opposite of that is not having one, which is unsatisfactory. And then if something happens, you have to report it. And if you don't comply with those, then there's a penalty for doing so. So while I appreciate the fact that there is some regulatory burden, there's lots of regulatory burden on businesses all over the place. This is one where you're providing a critical function in the economy, and you have to have your crash helmet on. And then if not, there's consequences for doing so because the role that you're playing is just too important for it to be left alone.
Our final questioner,
Chair.
Mr. Julian.
If I could, sorry, Mr. Julian, a very quick point of order. I know as members of Parliament we're away from friends and family a lot, so I wanted to take this opportunity to wish Miss Michaud a happy birthday today. I know she's here with us, and I just want to say happy birthday in public.
Happy birthday. Mr. Julian, please continue.
And as a special gift, we won't
I'm
sing
going to
to
take
you.
my 4 minutes, and then at the end, I think we should be singing to Madame Michaud. I'll hold that for 4 minutes from now. Mr. Chair, I think we all had questions for Mr. Newman and Mr. Holland, and so I'm hoping that we can have them back at committee. I know that's an additional expense because of the Conservative filibuster, but this is critical to get right, this legislation, and I appreciate the witnesses that have been able to answer our brief questions, but I have many more questions to ask. And so I wanted to come to Ms. Polsky and Ms. Barron. You're part of a coalition that has provided an excellent joint submission that talks about recommended remedies, 16 recommendations to this committee to improve the legislation. And they touch on a number of areas: restraining ministerial powers, protecting confidential personal and business information, maximizing transparency, allowing special advocates to protect the public interest, and enhancing accountability for the communication security establishment. Of these 6 recommendations, which are the most critical ones that we need to consider, or are they all as part of a package, something that's vital to make sure that this legislation does what it is intended to do, but does it in a transparent way? And I'll start with Ms. Polsky.
Thank you. And I think you hit on the key is transparency. And it's not a matter that one is more or less important than the other. They all have to be present for the legislation to be reasonable, fair, balanced, deserve the public's trust. They all have to be incorporated in the legislation. It's as simple as that. Without all of those components, there isn't the balance and the reasonableness and the proportionality that has to be there.
So what I hear you saying is the 16 recommendations are all interlinked, and without all of them, you and the coalition would not be prepared to support the legislation?
The legislation is important. The premise of the legislation is important. But there's the old saying, you can't do wrong fast enough. you can't lose fast enough. I think it's incumbent on us all to take the time and do it right, not do it over or have people suffer as a result of legislation that could have been done right in the first instance, but is being perhaps rushed through.
Thank you for that, Ms. Barron. I have the same question for you. Of the 16 recommendations, the ones that you feel are most critical to get right in this legislation?
Yeah, I mean, we've been discussing these various remedies for several years now, the civil liberties groups. And so I agree with Ms. Polsky that I can't sort of pick a favorite child. I would say that all of the recommendations overarching have the same purpose of proportionality, privacy, and checks on the exercise of unconstrained power. So they go together as a package, so I couldn't single one out. If I did, it would be one that I have particular expertise in, but that doesn't mean that it's the most important for the goal of cybersecurity, which we all agree is an absolute imperative.
Thank you. My question was more what is absolutely critical? Like what is where there is a line in the sand in terms of ensuring that this legislation's gotten right. And what I hear you both saying is that all of the recommendations are critical. So I thank you for that. My 4 minutes are up, but I think I would be joining with the rest of the members in singing happy birthday to Ms. Michaud.
Birthday to you. Happy birthday to you. Happy birthday, dear Christina. Happy birthday to you.
Thank you, committee, and thank you, witnesses. Appreciate your time.
Mr.
I
Chair?
will mention to the witnesses that there may be some more additional questions because your
Mr.
time is
Chair?
limited. And anything else you would like to submit to the committee, we'd appreciate it.
Mr. Chair?
Yes.
I would like to underscore that, but I would also like to invite the minutes or the witnesses to augment whatever submissions they've done with any specific amendments you would like to see, that you'd like to suggest. I think that'd be most helpful going forward. So,
Thank you. Thank you. Motion to adjourn? So adjourn?
Thank you.